Hello everyone. How are we today? Hope we've had a good day behind us. Again, it's 11:10 in Manchester, and I understand that's 7:10 p.m. in Hong Kong. So how are we doing? How are we all doing? So I've had some questions. Okay, good, good. Can you all see my screen? Yes, good. Okay, good. Thank you for the confirmation. So I want to address some of the questions I've had from you since yesterday. I'll start from the questions in the chat. So yesterday I told you about what the question on section 12 will be in the assessment. And I said that will be a problem question. Is going to be a problem question on section 12 in the assessment. So I hope that answers your question, Ding. I can't put that on Moodle because that's not what that platform is for. So if you listen to the lectures, you're able to understand many of the things that will help you in the assessment. So that's the answer to that question. It will be a problem question. So you do not have to prepare for essay and problem question. And from what I said yesterday, I said because it's going to be a problem question, you could go back to the final question we answered yesterday, the second question in the revision questions list. So I hope that helps. Now, I'm trying to see if there's any question. Um, no, no. Okay, okay. So yes, you only have to answer three questions. You only have to answer three. And like I said, you are able to choose whichever three you want. From the way the assessment is set up, no, it's not in parts. There's no part A or B. There's no compulsory question. So it's entirely up to you what questions you choose. I'll be telling us about the total breakdown of the questions. I mentioned it yesterday. I'll continue to talk about it in this revision. So that message I posted up there is an email I got from one of you. Thank you for sending the email, but I thought it was best to address this to the main class and just not respond to you in your email. So when we're talking about business to business contract or business to consumer contract yesterday, we we identified that the scenario was about a business to business contract because I think he was using the car in his delivery business. And I think what you're confused about in relation to Kevin is that there's a separate application of the HBA that talks about extra protection for some types of people. And what that protection, who that protection applies to, is someone that is dealing as a private seller, a private buyer. So that is different from identifying that this is a business to business transaction, if that makes sense. In the sense that even though he's using the car for his business, but that business is not a car dealing business, is not a car dealer. So for the purpose of the HBA, is a private seller. I don't know if you get that. So for the purpose of the sale of goods contract, it is a business to business. But to be able to benefit from the protection afforded by Section 27 of the HBA, he is a private seller. And that's just because his business is not that of a car dealer. So if you're the one that answered that question, that asked that question, I hope that clarifies that position. And in relation to the next point you raised, that you said, if yes, we're saying Kevin is a private purchaser in good faith. We said it wasn't in good faith because I think he bought it at a knockdown price. So him being operating in good faith was a bit sketchy. We didn't believe that. But if it was decided to have purchased in good faith, then your question is, can I say that the one before the final purchaser is always the one we should decide if it's a private? No. The location of the buyer is immaterial. You need to look at their business and be able to clarify whether they are a private purchaser under the HBA. So it could be the first buyer, it could be the second buyer, it could be any of the buyers. You just want to be sure that that buyer that you're looking at is a private buyer. Do you understand? So it doesn't matter what their location, what their position is. You want to be sure if it's a private buyer, it can get it can get title. And I guess in that case, the reason we're looking at, because title travels onward. So we're looking at the person that bought from the hirer. The first one, Kevin, did he buy in good faith? If he bought in good faith, he's able to transfer to the next person. Right. So there might be other purchasers. You're just thinking in terms of if this was a buyer from someone that is selling as a hirer. So that would be the second, not what you're saying that it has to be the one before the final purchaser. I hope that clarifies it. If it doesn't, let me know in the chat, or if you don't want to do that, send me another email and I can explain that to you since I've talked to the main group about it. So I mean, I've talked about the final question there, that is it in part A or B? Is it in parts? The assessment is not in parts. You've just got 6 questions. You choose any 3 you feel like doing, and then you're good. So I hope that helps. I'm going to take your silence as that helps, right? And I'm going to continue with what we're talking about today. So yesterday, we started with a chat about the right cell and section 12 of the SGA. And today we're moving on to the right, the condition of sale by description. So because it's a condition, it goes to the root of the contract. A breach will entitle the buyer to repudiate the contract. You already know that. So now, section 13, sale by description. What do you understand by that provision? What do you understand by sale by description? Why does it matter? We all buy things online, don't we? Yes, you can also post questions on Moodle. I'll get it in my email, or you can send me a direct email. So you can post questions on Moodle, Lee. Now, we all buy stuff online, don't we? At least I do. And yeah, yeah. So why do you think there should be conditions in terms of description when you're buying things? Why do you think this is an important consideration? Why? You could contribute in the comment section. So why is this important? Why is sale by description brilliant to protect the consumer? Very good point, Lee. This provision is there to protect buyers generally, not just consumers, bias. Good. To ensure we're buying the goods we want. The description is what triggers. Yeah, very good point. I don't know if you've heard about the joke of what I ordered versus what I got. Have we heard about that before? Where you see something that is really looking glamorous, beautiful online, and then it's delivered to you, and you're thinking, no, this is not what I ordered. This is not what I ordered. And there are lots of pictures on that online, lots of videos on what I ordered versus what I got. So this provision is there to protect buyers, not just consumers. Yeah, consumers need a higher level of protection, but every buyer does. Now, I want to talk us through um, why. So there's often that lack of clarity on what would qualify as a condition, right? So what we find is that statements could be found to be a mere puff. It could be, I've turned on my video because we're all looking at the screen anyway. So the statement could be a mere puff. I know we've heard these terms before. Can you put in the chat what examples of a mere puff will be? So if you're looking at something and you're seeing some words being said, what kinds of words would be mere puffs? Yeah, that's a very funny one, Lee. Drink enough Coke, then you will have a jet fighter. Yes, yes. The best bear, it is not an offer. Yes, we know that. Yes. Well, I like what you said about if you drink enough Coke and you have a jet fighter. Brilliant. So those are mere puffs. No reasonable person would take those things seriously because yeah, what's the link between Coke and a jet fighter? And also the best beer. I mean, who's determining this? So these are outlandish statements made by sellers just to get someone to buy their product. It's not an offer, yes, like you said, but for our purpose, it's not protected. If you find out that you drank lots of Coke and you still do not have a jet fighter, then you have no remedy because it's a mere puff. No one would take them seriously. Now, there's also what we call misrepresentation, which is what I call a lie when someone lies to you to sell you something, but it's at a higher level than mere puff in the sense that it can be taken seriously, and depending on the nature, you would be entitled to the remedy of damages because it's a minor issue. And if it's a negligent misrepresentation, you're entitled to repudiate the contract. But now, when it comes to the breach of a contractual term, if a core term, that is what description, sale by description is. This is the kind of breach it will be if you describe the goods to be of a specific nature and you find out that it's not. Now we've been told that there's so many ways to discover, like a mere puff, you know, you're not gonna have a jet fighter if you drink lots of Coke. That's very clear. But there are some gray areas where it's difficult to determine if a statement is a mere puff or if it's a term, a condition. So we're looking at this authority here that it's really all about what the parties want it to be. It's about their intention. And even though we're saying it's the intention of the parties, it is an objective test going by Oscar Chess and Williams that it is what a reasonable person in the situation of the buyer and seller would think. So if there is a bystander that says, "Oh, does that mean this?" They would both agree and say, "Yes, yes, that's what we mean." So it is an objective test. It's something that a reasonable person can relate to. But if that doesn't help you enough, these are some of the ways you would assess the intention of the parties. That is how you would know. So the first one, there are four main tests. The first one is how important is the statement and its truth. In the cases of Bannerman and White and Shaw and Reid, it's if the statement is important to both parties, you would see in their behavior, then that means it's a term. But if it's something they could do away with, they don't really care about that, it would be a minor term like misrepresentation or yeah, etc. Now, in Rutledge and Marquet, the court said the timing, when was the statement made? The nearer it is to when the contract was concluded, the more likely it is going to be held to be a condition, to be a term of the contract. So the timing is important. The nearer it is to the contract, the more likely, and the farther away from the contract that statement was being made, that means it's not likely to be a term of contract because lots of things could have changed. But if it was important to the parties, they would have maybe written an email or called to confirm and say, yeah, that thing we said the other time, we're still very keen on getting that. Now, the third test is if the contract was reduced to writing, is that statement part of that writing? So if you're negotiating, if you want to buy a car, you can talk on the phone with the car dealer, and then you've talked about lots of things. But if you're emailing them about the car, are you also including the statement that I want this to be a brand new car? I want this to have a four-wheel drive. I want this to be that. If that's reduced to writing, any of the statements making it to writing will be determined to be a statement, a term of contract. And the final point there is in terms of the knowledge of the parties. So if the person making the statement has more knowledge about the subject, we would take that to be a term of the contract. So if you're having a chat with a food expert or something of that nature, and they're telling you, oh, this food of it's described as this, it gives you energy, etc., then you're going to believe them. But if this was being made by someone of no knowledge, you won't take them seriously anyway because yeah, you don't know about what you're talking about. So why should we trust you? So these are some of the things you would see. But I don't think this is a major problem in the assessment because many of the statements will be a term, but it's still useful for you to summarize which of these tests you think applies. That's one of the ways you can distinguish yourself. But if you don't have the time, you can just write one or two lines about the tests. Say these are the four tests. In this case, probably this is it. But if you think it's controversial, it's complex, it's not clear, you might want to point that out. But if you don't, it's not fatal. What we're really testing is your understanding of the sections 13 and 14 in the assessments. So now, terms as opposed to representation. So if you satisfy the code, if you show the code that the representation is a term, you still have to clarify. Is it a warranty, which is one of the lowest terms? You get just minor damages for that. If it's an innominate term, that means it depends, its implication depends on how it affects the parties. So it could be something that looks like a condition, but you're looking at it doesn't affect you in any way, mate. It doesn't affect you. So that would downgrade it to be a warranty. So a nominate term could end up being a condition or a warranty. But if it is a condition, then that means you're entitled to um, damages or you're able to repudiate the contract. So that's the distinguishing factor between a condition and a warranty. You cannot repudiate the contract for the breach of a warranty, but you can for the breach of a condition. So now, having said all that, let's go back to section 13. That's why we're discussing term, conditions, etc. The law says that section 13 says sale by description is a condition. So it is those words that describe the product that can fall under Section 13. So not every statement. You may be able to institute an action and claim damages for the other m- uh, w- or other terms like a warranty, but you can you still what the point is you're able to claim for warranty for other terms, but if it's not under Section 13 and it's not a condition, you may not be able to repudiate a contract. Yeah. So not every statement that is a condition will be a sale by description. We know that Section 12 is also a condition, but it's not sale by description. Section 14 is also a condition, and it does not necessarily have to be a sale by description. So you could buy something that you've seen yourself and it's a sale of specific goods that you've examined and you're not relying on the expertise of the seller in buying it, but you may still be able to claim for non-satisfactory quality. So this is a separate claim. You can claim for this and you can also claim for Section 14, which we'll get to today. Now let's look at what the section says because the Act is a primary source of everything condition sale by description. So it provides that in this contract for the sale of goods by description, there is an implied term that those goods will comply with the descriptions. And the term is a condition. I've asked you, why do we need it? You said to protect the customer, consumer, to protect the buyer. So it's necessary. It's a necessary term. If we don't have that provision there, you're going to be buying lots of nonsense stuff all over. And we can see that if it's a B2C contract, if it's a consumer contract, the same provision is repeated in section 11.4 that the information given on the main characteristics of a product will be a term. And if it's a term, it's a condition. Now, we do not have a statutory definition of what a sale by description is. But we do know, and the reason we don't have a statutory provision on that is to allow courts some flexibility. Things are constantly changing. You can imagine in the past, if you're buying a cassette, there was nothing like a cassette, there was nothing like software in the past. But now that we've got it, just imagine if there was a definition in the act. Would it be broad enough? Would it be wide enough to cover that? So sale by description will include unascertained goods. So these are goods that have not been identified and agreed upon at the time of the contract. Because you don't know what product it is, you have to rely on the description given to you by the seller. You're trusting them to do the right thing. So that would be a sale by description. And also future goods. If the goods have not been acquired by the seller, you can't really point to it at the time of the contract. So that will also be a sale by description. So that's a very good question. You're asking Lee. Yeah, yeah. Lee, I would advise that you slow down to our level, right? Because you're so far ahead. We're just talking about sections 13 and 14 today, and we're going to talk about passing of title and risk, right? So when we get there, we will be discussing specific and uncertain because different rules apply to them, like you've said. So we will get to that. No, you're not jumping the gun. I see that you've done a lot of prep, and that's really good. I can see that. So we're going to talk about because it's got different implications in law. But what we're doing here is to understand what could be sale by description because that will help us understand clearly what the question, if you got a problem question on this, you can understand that, oh, definitely this is an uncertain goods. You cannot identify that, so it has to be a sale by description. So that just helps you get across that stage. You've gone beyond the stage of identifying what type of good is. And it's very clear. If it's unascertained, it's sale by description. If it says future goods, it's sale by description. But variations could occur when it comes to specific goods or inspected goods. But the laws still say, even if you're looking at the goods, that doesn't stop it from being a sale by description. We're going to look at the rare occasions where looking at picking up specific goods will not be a sale by description. But these are just the divisions we've got. Sale by description will include those two and may also include. So it is mandatory that on a certain goods are sales by description, future goods are sales by description, but the others may well be other things. Right, I hope that's clear. So that's why we're understanding. If you we're trying to have our understanding here. If you're faced with a question in the assessment, you know for certain, this is something that has to be acquired by the seller. Clearly, it's a sale by description. But if it's a specific goods, then there may be some doubts about it being a sale by description or not. So that's why the distinction here is relevant. Now, moving on to section 13.3, it says a sale of goods is not prevented from being a sale by description because it's been selected by the buyer. And that's a very interesting provision because when you go into the store, you do not know what you really want to buy. And in this age of lots of different products, you can see fat-free yogurt, fat-free this, and you're looking at it, you really don't know whether it's fat-free or not. So the fact that you selected it means that you may not know what it's in the product, but you're actually relying on the description on the shelf. Can we relate to this, guys? Can we all relate to going to the supermarket and picking up stuffs that we're relying on them? Does that make sense? Do you understand? Can we relate to this? For instance, you've heard about the free range eggs. You've heard about grass-fed butter. And you're thinking, well, looking at the butters, tubs of butter, I don't know which one's grass-fed, but I've selected this because it's written on the top that it is grass-fed. So that's still a sale by description. Do we understand the point I'm trying to make? If you understand the point, can you give me an example of when you can pick up some um items on the shelf? What type of item? Yeah, organic coffee. Brilliantly, brilliant organic coffee. We don't know. We don't know if it's organic or not. Organic coffee. No, it might be generic if it's you're not picking it up. But what Lee is say, yeah, okay. I think it's Lee that is answering. Kellogg's is best for you. Yeah, every day Kellogg's is best for you. Yeah, because you're selecting it. And people could argue that, you know what? You picked it up yourself. That is specific goods. You know what you're buying. Not really. You're picking organic coffee off the shelf, but you really do not know if it's organic or inorganic. Does that make sense? So going back to the previous slide, what we're saying is it may be specific goods or inspected goods. So the fact that the buyer has seen the goods, inspected them, or picked the items off the shelf does not mean they are not sale by description, if you understand. Yeah. So now going back to the question you asked in the chat, section 13.3, you said it applies to future goods. If it's a future good, more likely it's going to be a sale by description because if goods do not exist or do not belong to the seller, so he couldn't have shown you the goods, so you don't know what the goods are, you're relying on the description by the seller. Do you understand that, Lee? If it is specifically ordered, it is still, you're looking at a sample. Yeah. So if it is ordered, you're looking at a sample. and you're describing that this is what I want until you get it. Okay, so if it is a specifically ordered item, that's a different one, isn't it? That's a different one with specific options. Yes, yes, but it's going to be unascertained, except it is just that one, yeah, it's just that one good that exists. So say the crown of the Bohemian Queen. If it's one, then we would say that is specific goods, and that would be an exclusion. But I don't want us to get bogged up in what is included or what's not. You're not going to be faced with. We can talk about this for all we want, but in the assessment, it would be clear what item we're looking at, what item we're perceiving. So let's see. There's another comment. No, it's fine. I just don't want us to lose track of what's material. Yeah. So a sale of goods is not, it could be something selected by the buyer. The court will look at the facts, the matrix of facts. What were they saying? What did they believe in? Was there reliance, etc., in determining if it's a sale by description. So, yeah, I think I'm going too fast. Back, yeah, forward. Now, looking at the authority of grants and Australian knitting mills, right, set the record straight and say that there is a sale by description, even if that buyer is buying something on display before him on the counter, so long as that specific thing is a thing corresponding to the description. It is a sale by description. So organic coffee, Arabica coffee, a woolen undergarment, a hot water bottle. So the only circumstance where a shop sale is not a sale by description is where the goods are selected. You know, when you go to a thrift store, you're just picking up something and you hand it over, and there was no exchange of words from the buyer to the seller, etc. So it's not labeled. You're not relying on anything that has been said to buy that goods because reliance is a really good, is a key factor in determining what a sale by description is. So that description, and that's what I just said, reliance, it must be essential. It must be the core. It must be key to the contract. So the description must be essential so as to become a condition. And the best way to prove this is whether reliance has been placed on that description by the buyer. And we see the case of Harlingen and Leinster Enterprise versus Christopher Hall on that. So as the buyer relied on the description on the shelf, as the buyer relied on the description offered by the seller, if that's not the case, then you cannot say it's a sale by description. You cannot say it's a sale by description. For instance, if you've been buying the items for a while, that means we can assume you've accepted that it's that item that was being described. Yeah. So a sale will be by descriptions if they like. Remember, we said the intention of the parties is very key. So both parties must be on board in relation to it being a sale by description. If we know descriptive words were applied, how do we know that those words are description for the purpose of section 13? So that's a really key aspect. So we want to understand what the scope of the provision is. And Lord Atkin was very helpful in helping us identify what that is in Arcos Limited and Runansen. He said, if the contract specifies conditions of weight, measurement, etc., these are conditions that must be complied with. So if you're going to the store to buy a gallon of milk, it needs to be a gallon, not about a gallon. It has to be made that condition because measurement is a really key aspect of the merchants, the market. Measurement is very key. So a ton does not mean about a ton. A ton is a ton. A yard is a yard. If the seller wants that addition, they would specify it. They would specify it. So when it comes to things of that nature, the measurement, that is very key. And we see this in the decisions of the courts, including Remo and Landor. They are very strict when it comes to the doctrine of compliance. So I want to ask us, why do you think we can justify such a strict approach? Should the courts allow some flexibility in relation to compliance with measurement, with description? Should that be allowed? For clarity and certainty, depends on on the type of goods. Yeah, absolutely. But I think when parties contract and the seller has made some statements describing the items and the buyer is relying on that, it would be a good idea. Just imagine, I think there's an authority there where the wood measuring 1/2 inch was delivered when it was above 1/2 inch. And what this means, for large construction companies is that do they have to start filing it down? That minor discrepancy could lead to hardship for the buyer. So that's why the courts are very strict. But we see that in more recent times, courts have been a bit relaxed in their application of what this means, right? So in the case of Reardon Smith, the court said you can ask whether a particular item in the description forms a substantial ingredient of the identity. So if we're saying that there's been a variation in the item, does that change the nature of the item? So if you're buying a pet, a a type of bulldog, give me examples. If you're trying to buy a type of bulldog and then they're giving you a chihuahua, yeah, a dog is a dog. Boy, chihuahua is different from a bulldog. So, yeah, that's completely off the mark, right? But what could be nearer the mark, Lee, when we're talking about bulldogs? Could it be the XL bully? Could it be the other ones? So these are the gray areas that the courts are trying to, yeah. So when it's totally off the mark, it's easier. But when it's close, someone will say, yes, this is the breed I'm asking for. This is the breed I'm trying to get. But you know the way people play around with the breeds, they just add crossbreed with this, crossbreed with that. Yeah, absolutely. So if the identity of the thing sold does not change by that variation, for instance, an half inch plywood is different from a 3/4 inch plywood. In the market, yeah, we're looking at what the people do in the market. It's entirely off. It will not be useful for the same purpose. These are when specific measurements really matter. So again, it goes back to what we just said. Description must go to the identity. So if goods comply with description, they may not be fit. Goods may comply with description but not be fit for purpose. And we saw that in the case of Ashton Pigres, that when an item is not fit for its purpose, this may mean that it does not comply with its description. So if the purpose of coffee is to be drunk, and then you're buying one that can be drunk, yeah, absolutely. So going back to the authority, Ashton P. Grace, Lord Diplock was of the view that description is restricted to words in the contract that were intended to identify the kind of goods that were to be supplied. And the test is, do we expect the buyer to reasonably refuse to accept the physical goods because they did not correspond with what was said about them? Right. So this is a really good one in the sense that I want to give us a scenario on that happened to me. So breach of section 13 is useful if the seller. So I'll just tell us about the scenario. So I was browsing on Amazon and I wanted to buy a desktop computer just for my child. And I wanted to buy a refurbished one because I just didn't think I should buy a new one. And I saw that the one that was refurbished, excellent, excellent. They say refurbished, excellent. That was £180. And the one that was refurbished, good, was £150. So I paid for the one that was excellent because, of course, I wanted to buy the best and I was willing to pay the extra. Now, when that computer was delivered, the screen was sprayed over at one corner with black paint, and I think they were trying to make it tight and neat and all that. So they sprayed black paint at one corner. The USB ports is only three of them that were working, and for those three, one would take, yeah, I'll come to example. From those three USB ports that were working, one would take the Wi-Fi toggle, one would take the mouse USB, and one would take the keyboard. So in essence, that computer would not accept a USB if I want to add a document or a file or whatever. And that's not the only thing. The mouse, no, the keyboard was broken in half, and I think that was due to packaging. And there was some other issues there. Now, looking at what happened in that case, would you say that was delivered excellent? Was that an excellent computer, or was it something less? So screen was sprayed over. One of the USB ports was not accepting USB. It wasn't you can't insert a USB into it. And also the keyboard was broken in half. So is that a computer set? Do these defects change the nature of what was supplied? Is it still a computer set or not? Okay, if you don't want to talk about that one, not usable. Yeah, it's not usable. It will still work. The Wi-Fi toggle was slow, but it was still a computer. And now, because it says it does not lose, yes, it was still a computer. It does not lose its identity. Was it excellent? No, it wasn't. So if I wanted to sue for that, I wouldn't be suing for description. Yeah, it's still a computer. Thank you. I like the feedback. So I would still, it's the computer. If I was going to sue, I wouldn't be able to sue for not matching description. Yes, they called it excellent, but there's something better I could sue you for, which is the next section, section 14. It was not of satisfactory quality. And when they said excellent, good, that's really about the quality of what you're getting. And it's a second-hand, refurbished, you know, potato, same difference. So yeah, now going back to the question that was asked, there's a question here that what about this for an example? You buy a leather strap for your luxury watch and you ordered for a specific type of cow hide. You want that specific cow, but the watch manufacturer used the wrong type of cow for the leather. Is it still a breach? Of course, something has been breached. The question is, what is that thing that has been breached? So I guess your question is this a description issue? Is it section 13 breach or is it section 14 breach? So what do you guys think? What do you think? It's a different leather. And the question you want to ask yourself is, does that leather difference go to the identity of the watch? Does it say in the description, cow A hide leather watch? If that's what he said, then you might say it goes to description. But if it's a different type of leather and you're saying the one supplied is of inferior quality, then you might want to sue under section 14. So the main question you're asking yourself if you're faced with a question on sections 13 and 14 in the assessment is, does that defect go to the description? If you add that thing to the product, does it change the identity? Does it change the identity of that thing? If yes, then description section 13 is the right section to use. If it doesn't change the identity, like I said with the computer, it was of an inferior quality, but it was still a computer. Defective, you will look at it and say, yeah, it's still a computer. It would be different if they sent me a CD player. Yeah, that's not what I asked for. So that would be section 13. So that's a good way of just ask yourself, does it go to the quality of the item? If it does, yes, that's if it changes the identity rather, then that means there's been a breach of section 13. But if it doesn't, there has been no breach in my case and in relation to your leather watch, except that leather watch has been described as cow A leather watch. Now, the breach of Section 13 is very useful because there is a lot of caveats when it comes to Section 14. So you may want to sue if the seller is not acting a course of business under Section 13. Because to be able to sue under Section 14, it has to be acting in the course of the business. So that's the distinction between the two sections. Again, reliance, yes, yes. So there must, you remember we talked about, so someone is saying, Tuen is saying in the comments that it depends on, no, I think that was someone else. Hong was saying, it depends on whether the buyer relied on the description. And remember, someone has to make a description, has to make a statement, has to make a represent, I don't want to say representation, has to make a statement, has to say something, and that thing has to be relied upon by the buyer. So that is how we know what their intention are. Both of them have agreed that this is what they are selling and what they are buying. Now, the next question, the next comment or question by Tuen is, if the statements say heavy load 100 kg and the washer can indeed only carry 50 kg, can we argue that it goes to change of identity or it will go to quality? So that's a very good question. And I want to ask the other students present, what do you think? 100 kg versus 50 kg? Description, yes. Description. I would think it's description because it says 100, that's times 2 of 20. So yes, it's still a washing machine, but it's a different type of washing machine. And the kind of clothes you would use 100 kg for maybe industrial, but 50 kg could be for something less. So it looks like description. But what we do in the assignment, in the assessment is you can argue both ways and say, looking at this, it's not something about the quality. It's really about the type of goods we're talking about. So if you're buying 100 kg, no one would suggest to you that it's a 20 kg. Does that make sense? Or is it 50 kg? Everyone knows there's a wide difference between 100 kg and 20 kg. I think I've had my share of buying things online and it being delivered and you're finding out it's the wrong size. Remember what we said? That half an inch measurement, those things go to description and the courts take them seriously. Does that help, Suen? Measurements, volume, 1 liter of milk, 1 gallon of milk. So does that help? Now we know, let me know if you need further clarification in the comments. So now we've looked at the breach of section 13 and know that it is very useful if you're dealing with a private seller, the person that is not, it has to match the description. It's applicable irrespective of the type of seller you are. Yeah. So we will now move on to talk about the next. We'll talk about the next provision, which is section 14. But do we understand what section 13 is asking of us. I think we're going to talk about quality now because I'm seeing the question here. Even if it's, remember the courts, let me just take the slides back and show us. Yeah, let me take this, share the slides that we just showed us where half an inch, a minor discrepancy from half an inch was considered to be a breach of a condition. So share, where was that? Um, I'm scrolling there now. See, our course, the court said, if the seller wants a different thing, he would he would say so. We say here that conditions of weight, measurements, and the like must be complied with. And these are talked about under description. If we're saying it's excellent, it does this, it does that, then that would be quality. Does that, do you understand that? Does that does that answer your question? Stop share and then I'll share the next. Does that answer your question? Even if it's 90 kg, even half an inch, the courts were very keen on applying it as it is. So I want to quickly go through the next section so we can answer questions on that. It's a really heavy thing, so we may not go to the next to SGSA today, but we'll see how it goes. We'll see how we're able to uh how much we're able to cover today. We've looked at, yeah, yeah, you're welcome. So I'm trying to get my slides for section 14. Where are you? SGSA, no, not you. Section 14. Yeah, I think I might have to open it again. Section 14, quality. So now, moving on to talk about quality. I think that's what happens when you've got lots of windows open. SGSA. Yeah, I think I've seen you. Sorry for that hold up. Now, let's talk about section 14, which is really broad, is more broad than is broader than what we've had a look at. This section focuses on fitness for purpose and satisfactory quality. This is the origins of the obligation more than 100 years ago, 135 years ago. Oh, yeah, I think so. More than 40 years ago. The court in Lord Ellenborough said it cannot without warranty insist that it shall be of any particular quality or fitness, but the intention of both parties have to be taken into consideration. But we want to be sure that it has to be of a sellable condition. You cannot sell something in the market. You're not selling rubbish, but except you want people to use it for biofuel. I think Ellenborough will think twice about this now. But whatever you're selling has to be sellable in the market. You're selling it to someone. It has to be something someone else is able to buy from them under the denomination mentioned in a contract. So a purchaser cannot buy something and then lay them in the dumpster or whatever. You're buying something that is of value. It has to be of marketable quality. And that was the term used then. So let's look at the specific provision of that section, section 14.2. I want you to be citing this in the assessment, as in right sections 14.2. You don't have to put all of that there, but it's not even too much. So you may put it there if you're hope if you want to. So the law provides that. Where the seller sells good in the course of business. And remember, this is the main distinction between Section 14 and Section 13. For Section 14 to apply, it has to be in the course of business. That seller has to be in that business of what he's selling. So in the course of business, there's an implied term that the goods are of satisfactory quality. And we've got a repetition of that in Consumer Rights Act, Section 9(1) for B2C contract. This term, selling in the course of business, has been given broad definition. So you see that the courts are very willing to allow lots of claims under it. In the case of Stevenson and Rogers, the fish seller, a fisherman that is in the business of catching fish to sell, sold his boat. And he claimed that court and the boat wasn't of marketable quality, wasn't of satisfactory quality. And he argued in court that, yeah, I'm not in the business of selling boats. I'm in the business of selling fish. And the court said, no, no, my friend. The sale of a boat is in the ordinary course of business of a fisherman. And you can see the lengths the court are willing to go to protect innocent buyers. Yes, you are selling this in the course of business. You're a fisherman. You use a boat. You know what a good boat looks like. It's just like, and for this purpose, if an Uber driver sells their car, it would be decided to be in the ordinary course of business, um, and Section 14 would apply. Does that make sense? So you can think about this authority Rogers, Stevenson's and Rogers when you're applying the section. So what are goods? What are goods? We can be tempted to say if you go to the restaurant and you're buying crisps or you're buying a snack coming in a nylon wrapper, people might argue what you're buying is not the package, but the court said no. In Gedlin and Marsh, the packaging is included. So in this case, in Gedlin and Marsh, the seller sold bottled water, breakable bottles, the glass bottles actually. And that glass bottle wasn't of good quality, so that meant the bottle broke and hurt someone in the process. And the argument was, no, we're just selling the water. We're not selling the bottle. And the reason they made that argument is because, back in the day, when you're buying maybe Coca-Cola or some drinks, you have to return the bottles. So the bottles is not part of what you retain. The court said, yeah, that is still the product. You can't say because it has to be returned by the buyer, it's not the product. So it includes packaging. And in the case of Warmel and RHM, the court said the instructions were included. In this Warmel case, the farmer used the chemicals supplied, and he claimed they didn't work well. They didn't work as they should. And the seller said, yeah, if you read the instructions, you would know how to use it. He told you to use it earlier. And the court said, yes, instructions were included in the goods. And in the current age, with 16 Harbans holding that if you're buying a case set, if you're buying a disc, this is not just the physical disc that is the product. The goods, the software, the music in the case set are also included in what we define as goods. So you see how we're able to define that. And I see some really good students in the assessments engaging with these cases and showing that goods could include this and determining these are goods for the purpose of Section 14. Now let's dig into what these provisions are. Satisfactory quality, that is a requirement for all types of goods sold in the ordinary course in the course of business. But if the buyer has made the purpose for which they're buying the goods known to the seller has made it known to the buyer. Oh, I misspoke. Then it has to be reasonably fit for that buyer's specific purpose. But remember, it has to inform the seller of this, and there must be reliance as well. So, what do we mean by satisfactory quality? It was replaced in the Act in 1994 in that amendment, and we see that they're not fundamentally different. It's just trying to use terms that are really familiar with the audience in the current day. So yes, at the times different, not necessarily. The other older cases are still being applied in recent times. So now, digging deeper into the provision of Section 14(2) in regards to quality and fitness, the law provides that the goods must be of satisfactory quality, and it defines what that means. It says is the standard. Again, we're talking about a reasonable person. Who is that person? No one knows. But it is what a reasonable person would expect, having regard to what this goods has been described as, the price, and the state and condition. Now we know that if you're buying something that is refurbished, like in my own case, or something that is second hand or used, you won't expect it to be top tip. You don't expect it to be top notch, right? And going into section 2B, I think this is where some students make mistakes in their assessments. They don't do that. But you need to engage. You need to really apply those four um, conditions, those four things. So fitness for all purposes of goods of that kind are commonly supplied. That's what we're expecting. Having consideration to what does it look like, the appearance and finish, their authorities on this, freedom from minor defects, the safety, is it safe? If it's not safe, we can't say it's of satisfactory quality. If it's not durable, durability, I mean, it depends. It depends durability. So you have to really engage with section 2B, subsection 2B rather, and there's that comparable term. So everything we're looking at, it's comparable with the Consumer Rights Act. Even if you're getting a question on a B2B contract, you might want to point that out, that if this were to be a consumer contract, then this is what the case would be. And this is just you showing an appreciation of the wider context of things. But don't go into too much detail when it comes to a consumer if the question is not in relation to a consumer contract. Now let's talk about what a reasonable person would expect. The co- the transaction will be saying in what if the goods, if it's a appearance and finish. So is it brand new goods? Is it second-hand goods? You wouldn't expect the second-hand goods to be perfect because you know you're not paying the same amount of money for second-hand compared to brand new. And goods sold as soiled. So if the goods are already telling you, the shops are telling you this is a clearance item, it's not perfect, you know you don't expect it to be top notch. Now in the answer nod, Lord Denning said you should have thought a fair way of testing mercantile satisfactory quality would be to ask a commercial man, do you think the buyer should be able to reject this goods for this defect? And the answer to that will tell us what the law is. So we're relying on a reasonable man. We're looking at the price paid, right? We're looking at the price paid. How much was paid? What about goods sold on sale? I mean, you would still expect it to be usable, but it doesn't have to be perfect. Now, in the case of Godley and Perry, it was regarding a catapult that a child bought, and in trying to use it, the catapult took his eye away from him, and the court said, yes, there's been a breach of satisfactory quality. What would a reasonable man say? You shouldn't be losing, yeah, having accidents like that. The catapults, you go forward, not backwards. So in that case, the claimant was entitled to recover damages from the shop owner, and the shop owner was able to get damages from the manufacturer, etc. And there's also other cases there, Brown and Craig's, Rogers, etc. Now, fitness for all the purposes of the kind are commonly supplied. So if goods are sold only for one purpose, then they must be fit for that purpose. And that's the decision of Grants and Australian eating meals. We have situations in which a good, a type of good. can be fit for all purposes, but that doesn't mean it has to be fit for every conceivable purpose. So let's be sensible about what we're expecting. So the fact that a yeah, I'm just thinking of what the example is. A computer is used for lots of things, doesn't mean you expect it to do everything you can think. Say you want to become a programmer, you need a different type of computer. You won't buy the very cheap ones. So, or you want to use a computer to mix me audio and all that. So that doesn't mean it has to be fit for every conceivable purpose. Again, we're going back to the reasonable man and asking him, do you think a computer should be able to tell you about the future? And he was thinking, not really. I mean, if you're, yeah, that's not what you expect from a computer. Or do you expect yeah, yeah. So those are the cases we've got there. And also, if you've inspected the goods, the appearance and finish, we would expect that there is that freedom from minor defects. But remember the minimis not curat lex. The law does not bother with trifles. Second-hand goods are not expected to be excellent. They're not expected to be in excellent condition. So the court will consider whether the goods are new and the price paid for it. That would be a determining factor. And I think these are some of the things you need to talk about in the assessment. We're going to see that in the question we're going to be discussing very soon. So the price paid is a factor, whether the goods are new or second-hand, that's a factor. So we also see the case of Clegg and Anderson on the freedom from minor defect. In this case, that yacht, which cost a whooping amount of money, enough to buy an average house in England, but the keel was 800 kg overweight and it cost him that much money to remedy. The court said it's a new boat. You paid a lot of money for that. It wasn't of satisfactory quality. So the price paid and the condition, whether it's a good new or second hand, will be a factor. Now, remember that I said the law does not bother with every trifles with trifles. So if there is a minutest defect, this may not entitle the owner to reject the goods. So we're not expecting that everything is going to be top notch. If it's the minutest defect, then the court does not bother with that. So Clegg, let's see what that case is on. Now, I think the thing is, in most cases, I've not read that part of the case, but if you're looking at most cases, you're going to see that when a claim for Section 14 has been made, it is also likely that a claim for Section 13 will be made. Those are just they go together. So in fact, what lawyers do is to make claims for both and hope that the judge gives them one of them. But in this, looking at the fact that I stated on the slide, if the queue is overweight, it doesn't change the fact that it's a yacht. It's a new yacht. So it still meets the condition. It's still because what we're saying, 800 kg does not go to the identity. 800 kg queue does not go to the identity of the yacht. I don't know if you get that. It's still a yacht. It wasn't described as an 800 kg queue yacht. Yes, you're saying it's measurement, but when we're talking about what the boat does, it's not really linked to the size of the keel, if I get that right. It is measurement, but a yacht is to be driven on a sea, on water. Can it still do that? Can it still do that well? If this is keeping it down and it's not able to do what it's supposed to do, then you can say, well, that's not yacht. That's not a yacht. Now, comparing it to the example you mentioned earlier about um, a 100 kg washing machine, if I get that right. You see, even from the description, the 100 kg washing machine is the description. because a 100 kg machine can do things that a 50 kg machine cannot do. But we don't know if a an 800 kg overweight keel is going to still be able to move. Why suspect if it's a car? I'm using my understanding of cars to answer this question. If the car is heavier than it's described, it would consume more fuel. Does that make sense? So in that case, you can say, yeah, that is a quality issue, not a description issue. Because being heavier doesn't change it. Yes. Okay. Yeah. I don't know about boats, but when this kind of cases come before the court, they will look at the fact that is more than just a summary on the slides and be able to do that. So if you're answering a question and you're very unclear on whether it's of satisfactory quality or just apply both. And remember, we're not going to penalize you for arriving at the wrong outcome. Yeah, we're not going to we're not going to penalize you for getting the wrong conclusion. That's not what we're doing. We're looking at your arguments. We're looking at how you've applied the law. Is it logical? Yeah, so that's what we're looking at. So now you're saying actually with cars it depends on the adequate weight and the lightest is possible. And I'm saying that goes to quality, doesn't it? It's still the car. If it's a 2022 Golf, being heavier doesn't change it from being that. But it just means it consumes more fuel, and that means it's of not good quality. Yeah. So if the overweighting if it alters the identity of the yacht, it turns it from a yacht to a boat. And I know this is confusing when we talk about the kg machine, but you know the kg machine talks about the capacity, how much it's able to wash, and the price you would pay would be determined by how large the machine is. So that goes to the identity, doesn't it? Yeah. Thank you, Wong. A ton does not mean about a ton, but it is not really in relation to the identity of the product. So an half-inch wood is an half-inch wood. You will find it difficult to see this being advertised in the topic, in the line advertising is saying yacht, 800 kg keel. You won't see that. It could be in the specifications, but it's not going to be the highlight of the yacht, if that makes sense. So it's not part of the identity. And that's why this authority is coming here, is not discussed under um what's it called? We're not discussing it under satisfactory sorry, um the condition of description. Yeah. Yeah. I'd like us to proceed because this is not going to be a problem in the assessment, and there are lots of things we should cover that we haven't. But I want you to be able to distinguish between the washing machine, which is you're going to the character will change if it's smaller because what you're buying it for could mean it's not it could mean it's not useful for that purpose. So I hope that lays that to rest. If you still want more clarification, send me an email and then we can trash it out. So now, yeah, we talked about minor defects. If a product is not safe, it cannot be of satisfactory quality, it has to be safe. So the question that what court wants to answer, the court wants to consider is this product, is it capable of being driven safely? If it's not, then it's not of great quality. It has to be capable of being driven safely. You can have a car that has got minor defects, maybe the light dims, but it's still you can still drive it. You can still fix that. And again, we're going to look at how much you pay for it. So the court will look at the ease with which the defects could be remedied. Yeah, pop out a bulb, put another one in, so sorted. Whether the defect was capable of being repaired as new, and these are the other factors the court will take into consideration. So durability is also a consideration. So there has to be product has to be of good quality for a reasonable time afterwards. But we're seeing that in the case of Lambert and Crowther, the court said for a reasonable period. I think in Lambert, the court was of the view that you became aware of this defect, and you becoming aware of it, that was when the period ends. So there's been that reasonable time between purchase, use, and the discovery. So it didn't happen immediately after you bought the car. So the court said, yes, it has to be reasonably fit for the purpose for a reasonable period after delivery. And in Thane, the court said, you know what? After 2 weeks, it was you get what you pay for. The price paid in this case was low, and if you want to distinguish yourself in the assessment, you can contrast the cases where the courts held that for a reasonable period and where the court said uh, d- for a reasonable period, that's Lambert and Crowther, these two cases. And the one at the bottom, the court said, you know what, 2 weeks, yeah, that's fine. How much did you pay for it? And that could be the factor. So I think the main rule is that it has to be durable for a reasonable period after purchase. But if you've paid a shitty price for it, pardon my French, then you're going to get what you pay for. But it still has to be workable. It needs to work. But don't expect it to be excellent. You've not paid an excellent price. Don't expect an excellent product. Now, there could be an issue where the buyer could be entitled to a manufacturer repair, but we're not looking at that here. That's a right in addition to the protection of the act. It does not detract from it. It does not remove from it. So you may still be able to sue even though you've got warranties and you can look at Rogers and Parish for that authority. Now, these are other bits and bobs on section 14.2c. Satisfactory quality does not extend to anything specifically drawn to the buyer's attention. So there's a I've forgotten what we call it, where estapel, where if you know about something, you're stopped from claiming anything in relation to that. In this case, it's been drawn to your attention, so you should know. And also, if the buyer has examined the product and these are defects that a naked eye should reveal, does not apply to latent defect. And defects would have been apparent on examination of the sample. You're not able to claim for that because you're aware already. And like I said, for every provision, there's a comparable section in the SGA. Now, moving on to section 14.3. This is when the buyer has made known to the seller the reason why they're buying the item. There is that condition that the goods will be fit for that specific purpose. So where the buyer makes known to the seller their purpose for buying the goods, there's an implied term that the goods will be reasonably fit for the buyer's purpose, and but there are exceptions. If the buyer just say, I'm just telling you, I'm not relying on what you're saying, or acts in a way that shows that they were not relying on that, or if you're trying to buy a car that drives, but you've been there, you've seen the car doesn't drive, you need to fix it, and you're saying, "Oh, I need to sue." The court is not going to protect you there, and the reason for that is it's a sneaky way of trying to get what you did not bargain for. You've paid a specific price for this item because you know the condition it's in, so you cannot buy it in that state and then sue back and say, "Yeah, it's not great, but you saw that, didn't you?" Now, in terms of overlap, the distinctions between sections 14.2 and 14.3, we can see that 14.2 is generally for any seller selling in a course of business, and section 14.3 is about specific purpose. So there has to be communication of that purpose to the seller, and there has to be reliance on the part of the buyer. If any of those is missing, you cannot rely on section 14.3. Yeah. Now, moving on to this one, I'm trying to get through this. Where the item supply has only one purpose, then the purpose will be known to the seller. You would assume, yeah, why do we buy coffee? Of course, we drink them. We're not buying coffee because we want to rub it on our body. So it has to be fit for drinking. It has to be edible, unless there's an abnormal feature. So maybe there's something that means that that coffee is different from what was being has a feature that is different. So this is one case that illustrates that C made known that he wanted to buy vehicles from D for the purpose of taking passengers in heavy traffic in an area with steep hills. So heavy traffic, steep hills, lots of people, but the vehicle could not fulfill that purpose. And the court said there's been a breach of Section 13 because this is a specific purpose, very distinct on hilly places, heavy traffic is a specific thing. So the court said the claimant had relied on the seller's skill and judgment. So this was not fit for that. But if it doesn't rely, the section will not apply. And remember, I said the provisions are conjunctive. Yeah, so I think you can ask your questions. I'm checking the time. We're going to go on break if that's what you're raising your hand in regard to. So we'll be going on break at one at 8:45 Hong Kong time, and we should be back at 9. Does that do you want us to do that? So that means you've got 15 more minutes into because now we spend 1 hour 20 minutes. And if I take 15 more minutes, that means we would have spent 1 hour 45 minutes. Is that okay? No need, no, Sham, Sham, no. We need to take breaks. People need to stretch their legs. So yeah, Sham, we're gonna take breaks. Yeah. So doesn't rely if it doesn't rely on the seller skill, by all means, you cannot claim under Section 14. I like the energy, Sham, but we need to let people stretch their legs. I don't want to get sued. Yeah. So finally, I think this is the final slide here. A claim for breach of Section 12 to 15 is strict liability. What does this mean? We don't care if the seller lacks the intention, if this was a mistake, they will be liable whichever way. So that was the decision of the court in Frost versus like Halsbury. Because if they're able to say, "Oh, I didn't know," yeah, you didn't know, you have to be liable. You pay damages, and they're able to repudiate. So let's see. Oh, okay, very good. We would get the sample answer of, you know why we don't give you, in an ideal world, maybe that's something we could do. But in the past, giving students questions kills their creativity because we learn from your answers as well. We learn from your writing style, we learn from everything you do. But we found that when we give students questions, they just apply the answer in a formulaic way, and that's not good for your creativity. So that's why we do not give you questions, but if you listen, you're able to understand how to answer. So now remedies and acceptance. And this is the part some students miss, and it just downgrades their mark. So when you're answering a question, you need to think about remedies. What's the remedy? Okay, repudiation. You can return the goods, collect your money, or sue for damages. But what could prevent the buyer from getting remedies? So it's an implied term where a buyer, the breach is an implied time, so you're able to repudiate. But Section 15A has a caveat. It has an exception that if the breach is so slight, is so minor that it is unreasonable to reject the goods, These sections 13 to 15 will be downgraded to the breach of a warranty. But remember, this cannot be the case for section 12 because it's a core term. What we talked about yesterday, it cannot be the case. But in this, you might want to talk about this if you think the claimant is not affected in any way by the breach. Now, one of the one of the provisions is that you can reject goods. I think I've skipped a section. No, you can reject under section 1314 when there's been a breach of a condition, and the relevant section for CRA is 15A for non-consumers, subject to section 15A for non-consumers. Sorry, and we've got a provision, lots of provisions on that in the CRA. For yeah, the buyer has not lost the right to reject if he has accepted the goods. So the fact that a buyer has not lost the has not has accepted the goods does not mean he has lost that. But that's for consumers. You can reject for the breach of a condition, and it has to be within a reasonable time. Don't sit on it. If you wait for too long, you may be deemed to have accepted the goods, and that's what Section 35 provides for. If you're taking lots of things away from this session, I would recommend you think about this section because lots of students do not talk about this, and it's a relevant part of the discussion. They don't talk about acceptance. They don't talk about the lost chance of rejection. So Section 35 says that you're deemed to have accepted the goods when you tell the seller that you have accepted them, even though they are defective, and the goods have been delivered to the buyer for a reasonable time, and he didn't do anything. He didn't say anything. I think in some cases, people will say 30 days, reasonable time, which would depend on the goods, the type of goods in question, the nature. But we also know that if the buyer acts in a way that is inconsistent with the ownership of the seller, we would say he has accepted it. One example is if he sells on the item or if he gives the item out on hire purchase. Disposing the item shows that you've accepted because you have acted in a way that does not recognize the ownership of the seller. Section 34 provides that you have a reasonable opportunity. If you have a reasonable opportunity and we're expecting that you should have used that, you will not be able to reject. So time is of essence. You need to act fast. Section 35 gives the right to inspect where you haven't done so. If this is something you bought online, you may not have had that time to inspect it. So that means that you you you, sh you when you it's delivered to you, you should have a look. You have a reasonable time to inspect it, and then you need to time is of essence. Just don't waste time. And these are other sections on deemed acceptance after a reasonable time. If you keep it, we're assuming you've accepted it. There's a situation where you can ask them to repair. That does not mean you've accepted it. That means you've given them an opportunity to redeem themselves. And if they've done that and you still want to reject the goods, you're still able to do that if there has been a breach. So it is no defense to say, "Oh, but you asked us to repair." Yes, I did, but now I've changed my mind. I don't want it anymore. There are other remedies here. Um, if you're discussing, you might want to point out whether it's a B2B or a B2C contract that there are different provisions in relation to CRA. You have that 30 days of initial right to reject. You can ask for repair, and you have the final reduction or price reduction or final right to reject. You have that as well. This is the regulation 2013 that says that you you can get your money back, you can recover the cost. And this was the law I cited to my Amazon. I cited the CRA as well. But this was the law I cited to the Amazon store place, and I was able to get the funds back, even including the funds of posting the item to the seller. So I think I'm seeing that some questions are, I'll turn on my video now. I'm seeing that some questions that have come through. Would you, yeah, what we're talking about, I'll give you the structure. We talk about the structure. You don't have to use what I'm giving you, but it's really, it really is up to you how you structure your answer. So it's up to you how you structure your answer, but I can give you some guidance on what you can do to get good marks. Now, you said, I'm looking at, I hope I've not missed sample, no. On slide 26, do you mean buyer will lose right of rejection? Yes. If you accept the goods, you've lost the right of rejection because in the commercial sphere, we we love certainty. Right. We need to be certain about what you're doing. So it's unfair on the buyer, on the seller rather, for you to keep the goods for a very long time and they've relaxed knowing that you've accepted the goods only for you to turn back 10 years later and say, "Yeah, I just woke up this morning. I don't feel like I want the goods anymore." That's not fair on the seller. So for that reason, the buyer can lose the right to reject. Does that help? I think I've confused Zoom about what to display. Can you confirm that you can see my screen with the questions? How many screens can you see? Kim. Okay. Yeah. Yeah, Bunny. Thanks, Connie. So I hope this clears it for you, Kim. Does this clarify things for you, Kim? I want you to respond on that. I want you to, yeah, I want to hear your view. I'm going to Chrome. So it's a regulation. It's a regulation that applies to consumer contracts information and cancellation. It's the regulation that came into being. I've put the full name in the chat. So is there a mistake on the slide? Let me check. Which page of the slide are we talking about? Slide 26. I'll bring that up now. 26. So the buyer has not lost the right to reject because he has accepted the goods. Yeah, I think that came out wrong. Slide 26, yes. If you're not a consumer, if you're not a consumer, remember the CRA. This doesn't apply to you if you're not a consumer, but remember the CRA. You see why we need breaks now? The CRA gives that extra level of protection to consumers, right? So this provision here is that the buyer, who is a consumer, has not lost the right to reject because he has accepted the goods. But there could be deemed acceptance, the right to inspect following delivery. I'm trying to get the slide there. Yeah. So if you are aware, trying to get the slide. So what we're going to do is to clarify this. I don't know if you can see your screen sharing. I don't know. I think I've shared lots of screen. I'll share the questions now. We're going to address that when we get back. And we're also going to talk about the buyer. The consumer has a higher level of protection compared to your ordinary buyer. And that's why I want us to focus on. And we'll talk about this when we get back. So this is the question. Questions 3 and 4, those are the ones we will answer. If you've got further questions, put it in the chat. And we're going to talk about that in the after we get back from the break from our break. So yeah, re regarding acceptance. So what about Richard open regarding acceptance? So Lee, what does that case say? What's the authority? Yeah, it's not, it's to be fulfilled, a breach of a warranty, treating a contract as repudiated, unless there's. So if you've accepted, in relation to acceptance, the right you lose is the right to reject. If you look at the slides, that's what we said. You lose the right to reject, but you're still able to claim for the claim damages, if that makes sense. Do you understand? Wong, do you get it? So saying you've accepted the goods doesn't mean you're unable to get something. But the court actually allowed the buyer not to buy it. The buyer has bought the item already. So the others can go. Is it okay to return to this after the break? Yeah. Yeah. See you soon at 9 p.m. Hong Kong time. Yeah, 9 p.m. Yeah. Welcome back, everyone. Yeah, hope we had a lovely short break. So now go into the comment section and um rook us earlier about what's on the slides. So I want to go back to sharing the slides. That is the cause of confusion. Yes. Can you see my screen from current? So did anyone have the chance to, thank you all, good. Did anyone have the chance to look at what Section 11 provides for during the break? No? Okay. So generally, a buyer can reject goods. That's the general rule. But this is a rule that applies, that admits to exceptions. And we say it is subject to Section 15A for non-consumers. Remember, when we're talking about consumers and non-consumers, someone acting in the business course of business, we say the law tries to protect the consumer because using your Taobao, using your Amazon, you cannot negotiate. So back to this provision, it says the buyer, and where the omission comes from is we should have said the consumer buyer. Does that make sense? So the consumer buyer has not lost the right to reject because he has accepted the goods. If we look at section 11 of the SGA, subsection 4, it directs us to the exceptions to the rule in sections, is it 19 to 22 of this SGA? Because I've got that open somewhere, trying to escape from this. Yeah. So I've had a look at the Consumer Rights Act that I'm hoping you're also able to see. And looking at sections 19 to, is that the CRA? Due diligence, Consumer Rights Act. Oh, that's the wrong legislation, but it's fine. Have a look at that, and you're able to see that the consumer does not lose the right to reject. And this is because initially, when that provision was made, there was a lot of confusion on can a consumer reject? Can we have the principle of deemed acceptance with consumers? And this has been resolved. So the answer is no. There's a higher level of protection for consumers, and that could mean that it's in the interest of the consumer to keep the goods that do not meet these conditions for as long as they could. Remember what we talked about in relation to Section 12. So now going back to the authority that one of you shared with me, um, I'm trying to bring that up here. Record and Openham, where you said where a contract is not severable and yeah, the breach of a condition to be fulfilled by the seller can only be treated as a breach of warranty, unless look at the decision, look at the time of this judgment. It was decided in the 1950s. That was before we had damn amendments. We had more protection to uh for the buyer. So does that make sense now? Currently, a buyer is able to reject that principle of deemed acceptance for keeping the item with them for a while does not apply to consumers, but deemed acceptance applies to someone dealing as a business. So does that answer your question about this authority? So this authority is no longer good law when the buyer is a consumer. Yeah. So does that, I hope that clarifies that, Lee. And I'm looking at what happened was that the buyer's car wasn't delivered on time, could revive his right of repudiating by giving reasonable notice. Okay, all right. So I hope that's, yeah, yeah, it's a 1950 case. So we see that. So you're right to be confused about this because that was the situation with lots of people when that act when the amendment came to being, people were asking, is it still possible? Can a buyer lose the right to reject? Da, da, da. But it was decided that yes, um, as a buyer, you deemed acceptance does not apply to you. So I'm trying to bring up the questions. Now, looking at that questions, what you're asking me for a structure. Let's get into it. What did we do like yesterday? What was the first thing we did when we looked at the revision question that we addressed? What did we do? What was the first thing we did? We asked ourselves, what contract type? CRA or SGA? Yeah, because that's what's going to help you determine how you're going to answer this, what the applicable rules are. Remember that many of the provisions are similar, but when it comes to acceptance, rejection, remedies, there are some variations. So yes, that's the first thing we did. So that's the structure. You're saying, so this is the case about da 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 da. Yeah, it is a business to business transaction, is a consumer B2C transaction. Now, having done that, what's the next thing? What is the next thing to do? Statement, yes. But there is something we should have done first. I was expecting to say that when I asked about the next thing. Yes, you get it. The issue. Yes, what is the main issue? What is the main issue? Yes. Do we know what the main issue is? Do we know what that is? Anyone? I see you're typing away, so I'll wait for you to tell us. Defects. So they're defects. So you want to ask whether there has been a breach of, whether there's been a breach of what? So whether there has been a breach of sections, yes, good, implied terms, sections 13 and 14. And if there's been a breach, what does the final line in the question say? What's the final line? It says advice. So you're saying whether there's been a breach, and when there's been a breach, what are the remedies? Brilliant. Yes. So by doing that, you've demonstrated to the marker, to the examiner that, yeah, I know what this is all about, and I'm going to get cracking. So after identifying the issue, talking about this is a business to business transaction, business to consumer, then you go into the relevant sections. But let's first, is it business to business? Is it business to consumer? Good, good. Yeah, good engagement there. So what type of contract is it? What type of contract is it? Is it B2B? And why did you say that? Yes, yes. So in answering this question, you want to go through all that, and those are what we call the preliminary issues, the preliminary matters that you need to get out of the way. Without getting that out of the way, you've not really done a good job of answering the question. So you decided these are the main issues and those are the things you want to apply or you want to discuss. And this is a business to business transaction. And as a result of that, this is the act that is applicable, the SGA. You say that, right? You say this is the act that is applicable. And then you get into it. So you say in considering the applicability or otherwise, of the agreement. I mean, what's the primary consideration? It is whether Mary uh, and Shabby the agreement. Is it a sale agreement? Is it a sale agreement? So that's, are you looking at the points? Tell us, is it a business to business transaction or business to consumer transaction? Is it what was relevant sec statute? After going through that, is this a contract of sale? Because if you don't prove, good, you're going to apply section 2(1). So I hope the person asking me for structure, I hope you get what we're doing here. Do you get what we're doing here? We're going through steps, and that could be your framework for answering the question. Determine the issues, or you can start with the issues, or you can start with this being a business to business transaction. Tell us, section 2, there's a price consideration. It's there will be transfer of property in goods. Yes. So this is the I mean, it involves an element of part exchange, but predominantly it is a contract for the sale of goods. And for that, you've got the case of Snedon v. Durant. I'm typing that in the chat, Snedon v. Durant. So that's what you can use to prove that, yes, the contract of sale under the SGA. And then you proceed to talk about the other, yeah. So you want to ask, does the good conform with the contract? And by way of conformity, we're talking about the description. Does it comply with the description? We can see that, so that's, you've identified the first two, three things, and you're asking, we're going to be talking about description. And after talking about description, you'll be talking about quality and fitness for purpose. So, yeah, but you start with condition. We can see that Shabby, they're acting in the course of their business. So that's not a private matter. But in this case, the machine has got a leak. So do you think that's a an issue with the machine, or do you think that's an issue in relation to the way it was installed? Would you raise that question if you're answering this in the exam? So there's a leak. Is it due to installation, or is it due to the machine being faulty? We need evidence to prove cause of the leak. So you can say that you need evidence to prove, but you're going to proceed with an assumption that this is due to, is both possible. But because this is not an SGSA question, you're not gonna, you say if it's with installation, then that could be something that is you have to apply section SGSA to. But that's not the focus of this question. You want to crack on with your discussion on compliance with description. And for you to talk about description, statements have to be made. So, what are the several statements made by Shabby to the effect that the machine is? What are the statements they made in the question? Let's look at it. Do we know what the statements are? Section 14.2. Well, so the best thing to do is to start from 13. Talk about description, and if you think this is relevant, if it's not, you talk about. So what are the statements made? That's the first thing. What are the statements, guys? Super eco-friendly, yes. New. It was said to be new. It was said to be fast. It was said to be super eco-friendly. Because it was, if you say it's fast spin, you're saying it's fast, aren't you? So it needs to be considered if their claims from the terms of the contract form part of the description of the goods. So even if it's not a term, they could be actionable for misrepresentation if the statement they've made is false. But that's not the focus of this answer. We're not focusing on misrepresentation. But this is where you want to talk about statement will not form terms unless the parties intend them to be. And there are some things the courts will consider in the objective evaluation of whether the statements made are, yeah, I see all the comments, very good. So whether the statements made form part of the contract or they're just preliminary terms. So we want to ask, could the statements, could they really be in breach of section 13 on description? The answer to that question can be found in the act itself. What does section 13 say? So now you're going into the analysis. Remember the structure, you've gone through that, but now this is an analysis of section 13, right? So what did it say by description? I mean, they said where the sale is made by description, there's an implied condition that it will comply with the description. So what is it? What is the description? By asking that question, what is the description? You're probing, you're being critical, and you're saying, yeah, I mean, in the statute, we don't have a definition of a description. And in this case, yeah, brilliant hung. There's no definition. But in this case, what type of goods are they? What type of goods are they? Because in sales of uncertain goods, these may be necessarily sales by description. Because she did not, these are goods, yeah, actual, very good one. So, well, if it's a sale of uncertain goods, these are necessarily sales by description. If it's future goods as well, they will be sale by description. We said a different approach could apply to specific goods or goods, yeah. But in this case, certainly, she did. They are uncertain goods. So it is not clear in the on the facts. And we expect you to say this when you're answering the question. You can say, it is not clear on the facts if it's not clear on the facts. In this case, it's not clear on the fact. If Mary purchased an unascertained product or a specific fast being seen when she was at the store, we don't know. But the significance of this distinction is not relevant because even if you're pointing at something, how would she know it's fast Spain? It goes back to your organic coffee. You're looking at it. How would you know until you try it? How would she know? So even specific goods, maybe, maybe sale by description. And you might think, why am I wasting my words considering the eaters on a certain first? That is the way you build up your argument. You're trying to eliminate and you're trying to cover all angles. Yeah. So you're trying to cover all angles. So the distinction does not matter. In the case of grants and Australian knitting mills, the court said that even goods displayed could be considered to be sales by description unless these are sold without any words or goods being labeled. So if there is no communication at all between the seller and the buyer, then we would say, okay, that's not a sale by description because no, they did not describe anything and no reliance can be observed. However, you might want to point out that not all words will form part of the description. So you can, some words might be written there. That doesn't mean it's part of the description. And the courts in the past have treated descriptions very strictly. And so on that, we have the case of Remo and Lender is in the slides, as well as Harlingen and Christopher Hall, that the court in those cases said that statements must be essential so as to form a condition. It has to go to the identity of the contract of the item of the goods. If that word doesn't go to the identity, we cannot say it's a sale by description. So, so the first thing, there has to be that representation, and there also has to be reliance. And we could see the modern approach reflected in the comments of Lord Wilberforce in Reardon Smith line and Hansen Tangen, where he said that the party should ask if a particular item in the description constituted a substantial ingredient of the identity of the thing. So does it go to the identity? Is that the way we identify that thing? Or is it just some words that are just there randomly? And we know that this question of does it go to the identity comes up when, if the statements are essential, uh, will it form the substantial ingredients of the washer? Do you think the fast Spain is the kind of washing machine she wanted to buy? We can see that in the case of it does. You're saying it does. Yeah, it does. It is for business purpose, and she was willing to wanted to buy that specific thing, right? I would suggest that as well. But it's not enough to say it does. You have to prove it. And the way to prove it is so it's good for you to have that conviction in your mind that it is. It goes to the identity. But you also want to prove it by relying on cases, and some of the cases we've just talked about here. So you might want to cite the case of Ashington Pig Race versus Hill, where the sale was for Norwegian herring meal, fair average quality for the season, and it was intended to be used to feed some kind of animal. A preservative was added to those things, which reacted with it and produced a chemical poisonous to what they wanted to use it for. And the court said the term fair average quality for the season did not form part of the description. What's forming part of the description must go to the identity. In that case, that seemed like something that goes to the quality of the product. It is not the identity. So what forming part of the description must go to the identity, and non-compliance will be seen to change the identity of the good. It's something else now. It's not what we thought it is, because it doesn't because it goes to the identity. Why I said if you buy a car that has got yeah, or if you buy a computer that cannot come on yeah, maybe, I can't think of a relevant example, but we'll come to that. So new last season in Valley versus Whip, that case you cited earlier, was part of the description. So you might want to contrast it to like, what are the court on about? Why is it saying the description Norwegian fair average quality is is not description, but new last season was part of that. And the washing machine in this case was described by the salesman as being new. So we need to check whether the washing machine was delivered new or had it been used. If it's not new, then yeah, but we don't know in this case. Here, the machine was labeled a Fast Spin 200. It's a brand name and model name. It seems like that. And the law is that a brand name or model name will certainly form part of the description. Is if you're buying the type of computer with the model, that's what you want to buy, not something else, which is significant in Mary's case because she complains about our old machine working slowly. So what fast spin, that's the kind of thing she wants to buy, is the identity. Anything that is not fast spin, she doesn't want it. But an objective determination may indicate that there was an integral aspect of the description that was relied on by Mary in deciding to purchase it. So the question is this something she relied on? Is the fast spin what she really wanted to buy? Particularly looking at the nature of her business, and it goes back to what you said, Lord Chi. It's for a business purpose. She wants a fast machine because that's how she's able to deliver for our customers. So is this something that forced our decision to buy the machine or not? So the authority, the cases we've looked at, would suggest that the shabby claims of shabby really on energy efficiency would not constitute part of the description, or because that's more, yeah, energy saving is a quality. If it's energy saving, like you said about the car, the weight, it just really be about the quality. If it's too heavy, it consumes more energy, that'll really be about the quality, and that should be dealt with under section 14. So what we've done here is that we've not determined one way or another that it's a condition, is a Section 13 breach. We've applied the law and we're saying it looks more likely that the fast spin is a Section 13 breach because it changes the if it's a slow spin, that's not a fast spin. It's contrasting to fast spin. Now, having done that, you're saying so the claims of energy efficiency could be Section 14. And that's a really good way to segue into Section 14 and talk about quality. So what does the provision of the Act say? It says that in Section 14.2 that there's an implied condition that where the seller sells in the course of business, the goods must be of satisfactory quality. Now, the distinction between the two sections in terms of scope is not material here because she's able to claim whether it's in the course of business or not, because this is in the course of business. I mean, but it's not a private seller, so it doesn't matter anyway. If the goods fail to meet the purpose, the descriptions are likely not complied with. Do you have an authority on that, Hong? Because what we do in law is if you're making an assertion, you need to support it. Ashton Pigris and Christopher Hall. If that's what the court says, in relation to that, but it won't be very strict in that sense. Remember, we said if he doesn't comply with the purpose, that would be fitness for purpose, right? That's not description. So these are two separate provisions you're talking about. If he fails to meet the purpose, if he's not fit for purpose, the descriptions are likely not complied with. We have to be careful about sweeping statements like that because what you're saying in essence is that if there's been a breach of Section 14, there inevitably will be a breach of Section 13. But we know that these are two different sections. There's that likelihood, yes, but we have to be careful. There can be a breach of Section 14 without there being a breach of Section 13. So your question you're asking is, can I argue Mary relied more on the new condition as described? So Mary decides to purchase a new to do part exchange. Yeah, and the question we raised with that is we need to check with Mary, sorry, to be sure that um it was a new machine that was delivered, but we don't know for sure. So we're not exploring that into detail. It was described as being new, so we need to check whether it's new or being used. If it's not new, then that means that it doesn't match that description because it calls it new. So going back to quality, Section 14.2, we've had that, and Section 14.3 says if she has made the purpose known to the seller, the goods must comply with the purpose for which she has made that known. So we've gone to Section 61. We need to know the definition of goods in Section 61, which says that these are all personal chattels other than things in action and money. And we can see that the machine in this case is it's goods. It's not something else. It's goods. And in answering this question, you also want to talk about Section 14.2a, which provides that goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory. And then the other factors we did talk about, how much was the price paid, what's the condition of the goods, etc. You want to discuss that. You want to discuss that as well. So you're taking into account the description of the goods, the price, and all relevant circumstances. And 14.2b defines the quality of goods to include that fitness for all purposes for which that goods are being used. So if you're buying a car, you should be able to drive it. If you're buying a chair, you should be able to be sat on, etc. So it has to be fit for all the purposes for which goods of the kind are commonly supplied. And we're looking at the appearance and finish. It needs to have freedom from minor defects. It needs to be safe and durable for a reasonable period of time after purchase. And Section 14.6 confirms that that term is a condition. So if it's breached, Mary will be entitled to repudiate the contract. Now, looking at 14.2c, the requirement to be of satisfactory quality does not apply to any defect brought specifically to the attention of the buyer. But this doesn't seem to be the case here. I don't think shabby appliances made any attempt to send to call Mary's attention to any defect. So even in this case, she looked at the machine, she inspected it. Sorry about the noise overhead. There's something flying up there. So, if she has inspected the goods, she will be bound by any defect that could be perceived by the naked eye or which a reasonable person would have discovered. But that doesn't seem to be the case here. I mean, we don't think she carried out an inspection. Nothing was brought to her attention. She only identified the defects upon delivery. And at that time, it was too late for for the provision to be of assistance to Shabby. Yeah, it has to be inspection at the time of sale or before delivery. Now, one of the key considerations take, the court's take is if the goods were fit for all purposes for which goods of the kind in question are commonly supplied. In this case, we see that Mary is complaining about water leakage during each washing. The door regularly jams, making it difficult for customers to open it. Customers won't be happy with that because they might just think, why am I wasting my time going to Mary's laundromat? I'll go elsewhere where I don't have to go through this hassle. Aside from that, it is slow and often stops during each use. That's annoying. Even if it's in your house, you don't want that hassle. So where the goods supplied have only one purpose, it should be fit for that purpose. Grants versus Australian knitting mills. So what you're doing in the assessment is if you're citing a supposition of law, a provision of law, a statement of law, you should always support it with a relevant case. And that's what I've done here. Where goods supplied have only one purpose, it should be fit for that purpose. And this is an authority. This is stated in Grant versus Australian knitting mills. So you should always do that. But this does not mean it has to be fit for every conceivable purpose. And the authority for that is Balmoral versus Borealis. In this case, the washing machine does not seem to be able to do its basic function. It should be able to wash without stopping. It should be able to wash clothes without leaking. That's not the case. So this would suggest that it is not fit for purpose. So the quality is not sufficient, it's not fit, it's not satisfactory quality, and it's not fit for purpose. Now we know that when you buy things, you may have occasional problems. We can expect some minor problems to be, complicated electrical items. But these problems would appear to indicate something more serious and fundamental. And it's just too early. When did she buy it? It has to be of satisfactory quality for a reasonable time after purchase. So, well, when assessing if it carries out all the purposes for which you would expect a machine like that to carry out, the court will compare it to other washing machines. So the question is it the expectation that other washing machines would stop, would leak? That's not reasonable. That's not what happens. We will get the framework for the suggested answer. I think the point goes back to you doing this on your own. And in the past, people have people have done it. They've answered the question. So The danger in giving you a suggested framework is that it kills your creativity, and that's not what we want to do. You can structure it anyhow you want, just make sure you discuss all these other things. So you can discuss section 14 first or 13 later. That's entirely up to you, as long as you've covered everything. Hung, does that help? As long as you've covered everything that you need to cover. Yeah, a good structure will help pass the idea to your reader, to your examiner, but it's not fatal. We just want to be sure that you've covered everything that needs to be covered. And the framework for this is identify, is it a business to business or business to consumer transaction? If it is, tell us the relevant legislation. So I suspect you're writing that down because I don't think it's within our duty to give it to you, to write down that down for you. So identify what type of business it is. And the reason you're doing that is to get the relevant statute, know what the relevant statute is. Move on to consider if it's a, what's it called? What the issues are. And we identified what the issues are. Has there been a breach of conditions, section 13 and 14? Because it's a B2B contract. If it were to be a B2C contract, you'd be asking, has there been a breach of the relevant sections under the CRA? So that would be the second thing you're doing. And the third thing would be to define what a contract is, contract of sale is, and identify if this is a contract of sale. Of course it is, but you're applying section 2.1 to determine that, and you're telling us what the definition of goods are, going by the definition section. So I think that's the third thing. The fourth thing you're doing is looking at the terms in question, identify them. Good students will really write it new, fast Spain, latest super eco-friendly. You will write those terms down and ask yourself, are these terms or representations or mere puffs? And then after determining that, then you would go into the sections themselves. Section 13, if you like, start with that and determine if some of the terms made are description. Argue that, come to a conclusion on that, say there are other terms that will be discussed under section 14, and go ahead to talk about that. In talking about section 14, you're applying sections 14.2, which is a satisfactory quality generally, and then 14.3, satisfactory quality for goods for specific use that has been brought to the attention of the seller by the buyer, and then there has to be reliance. If you're done with that, you're commenting on if he's entitled, if the buyer is entitled to repudiation. If there has been a breach, which one of the sections have been breached? Is he entitled to repudiation? If he's entitled to repudiation, are there any bars? Are there any things that could affect that ability? In this case, do we think she has accepted? Deemed acceptance, right? You talk about that, sections 35, etc. And then you come to a conclusion, talk about the remedies, damages, section 15.1, section 11.4, if he's a consumer. So do you get the steps? Hung. You can list that down, what I've just said now, and listen closely to how we're answering this question and the next, because that will really help you. Right, Hong. So Hong Man, does that answer your question? Does that help? So yeah, okay, great. Thank you for the feedback. So moving on with what we're answering, the first thing we're talking about is section 14.2c, in relation to defects brought to the attention of the seller, to the buyer at the time, but that doesn't seem to be the case. And what the courts have done, we've talked about the case of Grant and Australian knitting mills, Balmoral's case. And what do you think about an ordinary washing machine? Would you expect them to leak? I would think not. Would you expect them to stop midway? Not really. They should be automated or automatic. Yeah. And then you want to go on to section 14.2a and say, yeah, you know what? When we're talking about satisfactory quality, we need to pay attention to the price paid. So these are all the factors that, yeah, good, good, low, chi. Yes, the price paid is a factor. The higher the price paid within the range of for the goods, the greater the expectation of quality. So that is a supposition of law I've made. If you have a case on that, note it down. But the authority I've gone on that is Brown and Craig's. Very good, Lord Chief. Very, very good. There's also, yes, yes. And you're contrasting thing versus you're contrasting that decision with Brown and Craig's. And there's also the case of Rogers and Parish. Very good. Very good. I like that you're paying attention. So you're applying all of that. And you're saying, yeah, talking about the case of Brown and Craig's, the House of Lord made reference to goods being sold at a slightly reduced price. Why are they reducing the price? Clegg versus Anderson, brilliant. Why are they reducing the price? Because they're benevolent? No, they're telling you that, yeah, reduce price, reduce quality. Reduce price, reduce quality. Now, we have to be wary when we're talking about prices because if it's not a throwaway price, you will still expect something substantial in terms of the quality. In this case, we know we can observe that the goods are on sale. So does that matter? Does it matter that it's on sale? Not really, because it's on sale, just it's not a throwaway price. So it is arguable in this case that the reduced price does not reflect any anticipated expectation of quality. But the reason they've discounted it is because maybe they're getting new items. Do you get the point? It's arguable, yes. It's arguable. It's on sale. But even if you're buying things on sale, if it's defective quality, we go out here, buy stuff on sale. You go out there, you buy stuff on sale. That doesn't mean it has to be rubbish. You're not buying it to put it in the dump site. You're buying it to be used. So how much was it discounted for? From 5,000 to 3,000? Yeah, it's still a lot of money. And you don't expect it to be leaking. Maybe there could be one or few scratches there. I don't know. But for it to be leaking and then stopping midway, that's just not it. So it's not a throwaway price. But what we need to investigate is how much do they sell washing machines of this range in the model and the brand. And the reason you're doing that is because we need to have that fact to be. So say if a washing machine of that brand is being sold for £20,000 and you're buying it for 3,000, that's almost like a throwaway price. But if it's 5,000-ish and you're paying 3,000, it could be because they want to change their stock, move it along and get new stock in. You know that. So yeah, absolutely hung. Absolutely. It depends on whether it's reasonable for the price, for the model and the brand. So is it too low that you would expect to buy a rubbish with that money or not? But even at that, even with that, you would still expect it to work. You don't expect it to be leaking or stopping midway. So in terms of the description applied, it was stated that it was new, but looking at it, you would have higher expectations than shop soiled or second hand. So maybe someone has poured something on it in the shop, or the second hand. You would expect less from a second hand. You would maybe you could stop one or two times as a second hand, but it's new. It's not shop soiled or second hand. So it should not have scratches in this case, nor should it have been used because it's new. It's new. Evidence indicates that to have been the case, it's not, it doesn't meet that level of quality you would expect. And you also know that freedom from minor defects is one of the factors taken into consideration by the court. So the failure of the doors to always open and the fact that it stops during use suggests that it doesn't meet this requirement. The question was described as eco-friendly and energy efficient, but yeah, it doesn't do that. So it's a breach of section 20, 14. It's not eco-friendly. It's a different quality because some people want eco-friendly because it's of better quality. They want to save the environment. So the quality is different. The durability of the goods, how long are they expected to last? That's also a factor. It's one of the things we talked about in the slides. So goods are expected to be fit for the purpose for a reasonable period after the delivery. We've talked about the authority of Lambert versus Lewis, and also the case, Thane's case, where the court said, yeah, it's just a reasonable time. You get what you pay for. So a heavy duty machine like this should clearly last longer than a few weeks. But we may want to investigate whether it was being used properly. So that could also be a factor. Was it overused? Was it used again, contrary to the instructions? Remember the case I cited on the use of fertilizers, and the court said the instruction comes as part of the goods. So if you're using the machine contrary to the instruction and it packs up as a result of that, you cannot claim that there's been a breach of quality. They're all together, the machine, the instruction, etc. So the standard is that standard expected by a reasonable person. So in this case, Mary is likely to have a claim on the basis that the machine is scratched. It's new. If it's used, it's a different thing, but it's scratched. It leaks. The doors don't open easily and it fails to stop or stops occasionally. So that machine is not of satisfactory quality and also does not conform with the contract, does not comply with the conform to the description. Now we want to ask, those are other considerations. It's still part of section 14, etc. There may be a breach of section 14.3 where the goods are sold and for a specific purpose, but this does not seem to, I mean, such, yeah. But in this case, a washing machine, you don't use it to cook, you don't use it to drive, you only use it to wash. So there's only one purpose for a washing machine. We might argue that in this case, it's a machine heavy duty to wash lots of clothes, but it's still washing. So there's that one purpose there. Now, it says in the question that there's a manufacturer warranty. What do you think about that? What's the position of warranties or the court on warranties? What do we think about warranties? Pop your response in the comment sections. Damages. Damages, that's the remedy, but with warranties, when you're buying something and they're saying, oh, you have 12 months warranty, you have 13 months warranty, that means if anything happens, they can repair it for you. What do you think? Ask to fix it, but do you have to go through that route? That's the question. So for that, we will look at the case of Rogers versus Parish. In that case, the Court of Appeal addressed the significance of warranties. Mustil LJ said that the existence of that is in addition to the buyer's rights, not a subtraction from them. I'll take that again. In Rogers, Mustil LJ said warranties exist in addition to the rights of the buyer, not a subtraction from them. So a consumer should not expect less from a product because there is a warranty. So Mary's warranty will have no impact whatsoever on Shabby's contractual obligations under the Act in relation to Section 13 and 14. So it is not a defense to say, oh, we have a warranty, she needs to use a warranty. No, our right does not, it doesn't diminish our rights under Sections 13 and 14. So now let's talk about remedies. And like I said, this is where students, they just talk about breaches and they stop there. But high-end answers, we talk about remedies. Remember, this is what he's asking you to do actually. Tell Mary her remedies. So the breaches of the implied terms under sections 13 and 14 impose strict liability. What does that mean? It means that there does not need to be any fault or any intention from the part of the seller. So she does not need to establish that they have, yeah, it applies irrespective of fault for faulty behavior from the seller. Thank you very much, Law Chief, for that. What remedies are now available? What are the remedies that are available in this case? What are the remedies, guys? Repudiation. Yeah, very good, Lee and Law. Yeah, repudiation. So she would want to go for them repudiation first, and then if that fails, she might want to go for damages. But let's talk about repudiation for a minute. Because there are conditions, rescission, yeah, repudiation, rescission, same effect. You're taking your money back. You're returning the items to them. Yeah, the implications are similar. So remember when you're talking about repudiation, because it's a condition, remember section 15A. What does section 15A provide for in this case? So section 15A says that a thank you all for that. A non-consumer buyer, someone that is dealing as a business, cannot reject the goods if the breach is so minor, is so slight that it would be unreasonable to reject. In those circumstances, the buyer can treat the breach of a condition as the breach of a warranty. So that's the application. So Shabi may want to argue. I know you can go straight to the breach is not slight, but remember you're awarded you're awarded marks for your application. So you want to start with the general rule. So that's what the section says. But you're arguing in this case but before you get to that argument, you have to weigh both sides. Shabby appliances will not sit on their hands and just be like, yeah, we don't care. We want to give you money anyway. So they would want to argue. So that's to answer your question, your statement, yeah, your comment, Lee Ming, that while these conditions we can say it's crucial, it's key. But what do you think Shabby might say? Shabby may argue that these defects are so minor, it can be fixed. Come on, Mary, it can be fixed. So she's not entitled to I see what you're doing, leaving. Yeah, $3,000. It's pounds actually more expensive than $3,000, but I get your point. But you know, they can argue that it can be fixed. So what they're saying is we can fix the leak and we can also fix the door. We can do all that, and the machine is good as new. That would be their argument. But Mary would say they go to the functionality and are significant. And she could also argue that she's losing customers as a result of this. She could argue that they're losing customers. So if we are to accept Mary's argument and say she's losing customers, she paid a lot of money for this, that means Section 15A does not apply. The right to repudiate can be lost anyway if she accepts the goods. And we can look at the law for that, at the law for answers to that. Under Section 35(1) rather, the buyer is deemed to have accepted the goods when he lets the seller know that he have accepted it. An acceptance could be by conduct. It could be maybe she continues to use it for a reasonable period of time after complaining, or maybe she sells it on. Under Section 34 SGA, on request, a buyer can give a reasonable opportunity, can be given a reasonable opportunity to examine the goods. So what that means is that if you just bought the item You can have some months, some days, you can buy something now. We read reviews online and people will comment and say, "Oh, delivery was great. I've not used the item." And I'm just thinking, why are you wasting our time? You've not even used the item. Why are you reviewing? I'm just like, well, why are people behaving like this? So the point is, as a buyer, you need a reasonable period of time after purchase to really understand how the product work. If you don't have that reasonable time, how can you claim it doesn't work well? So under Section 34, the law presumes that you need some time to be able to examine the product, and that means you're able to still retain that for a short while, for a period of time after purchase. But we see that Section 35(2) gives the buyer an opportunity to inspect the goods if he has not done so before. In this case, Mary did not examine the washing machine, so she's able to get that opportunity to examine the washing machine following delivery to confirm that it complies with the terms of the contract with the description. Shabi will want to argue in this case that Mary signed a delivery, and that goes back to what one of my professors told me that was very helpful for me in my undergrad. She said, make sure you're reading the question with a pencil and you're underlying the key things that you think are material. So if you've answered this question and you're not talking about the issue of uh waiver. Remember she signed a waiver. If you've not talked about that, you will be losing points for that. So if I were reading the question with my student eye, I'll be underlining that part that she signed. So that means exemption clause could be an issue here. So in this case, she she uh, she signed a waiver on the delivery notes stating that the goods were in compliance with the contract. How would she know? She just taking delivery. How would she know if the goods comply? She needs time to inspect. So what Mary can do is that, notwithstanding, the rule in Lestrange and Grocott, is that you're bound by whatever you sign. So there's that rule there. But in this case, Mary can challenge that note by arguing that it is unreasonable because there was no real opportunity to check the goods, and a right has been conferred by Section 35(2) of the SGA, as well as Sections 3 and 6 of Unfair Contract Terms Act. So she may be able to strike that term down for being unfair. Now, still, because acceptance remedies is a really key part of this question. So you might also want to talk about Section 35(6)(a), which provides that a party is not deemed to have accepted the goods merely because they've asked for a repair. So if Mary in this case says that she wants the goods to be repaired, that means she can still claim back the right to reject. So it's not enough to say because you said repair the goods. Asking them to repair the goods is just giving them an opportunity to correct an error. That doesn't mean they they will do it well. Now, this is the case where the seller repairs the goods. Very good. Thank you, Clive, for that authority. Connolly's case, fair also. Yeah, I like you guys. You're on fire. So this is particularly the case where the seller, having repaired the goods, refuses to provide the seller with refuses to provide the buyer with the necessary information about the nature of the problem repaired. And that means that they are preventing the buyer from making an informed decision about uh, whether to accept or reject. And for that, we've got the case of J&H Ritchie versus Lloyd. So if the seller is being difficult, they're not providing that detailed explanation of what's wrong. And it's in their interest not to let you know what's wrong. Because if you know what's wrong, you might want to just get off and say, I don't want it anymore. So if that's the case, you're still able to reject. In this case, Shabby refused to advise Mary as to the nature of the defect, so they've enhanced the legitimacy of her rejection. So that means she's more able to reject. In this case, when a repair is accepted, when you accept repair, that doesn't mean you've lost your right. It just means that you stop the clock for calculating what the reasonable time is to signify rejection. And to that effect, Section 35, sub 4 states that the buyer is only deemed to have accepted the goods when, after the lapse of a reasonable time, he retains the good without letting the seller know that he has rejected them. In this case, Mary possessed the item for just 20 days. So, if it's something that is not clearly visible to the eye, latent defect, the time runs from when delivery takes place. With some delay in rejection, it will be reasonable where the defects can be noticed immediately. So for that, we have the authority of Scots, a Scottish case of Douglas and Glenvagley Gill. I mean, Scott. We've got this case of Douglas. I'm typing it in the comment section. Douglas v. Glen Glenvagley, where in the case of Douglas and yeah, that authority, where a 16-month delay in seeking a repair was held to have been for too long, that was beyond a reasonable time to reject. And the reason the court said that there's no authority for permitting rejection for more than a year. And the case of Burstein and Pam, yeah, in the case of Bernstein versus Pan Motors, a period of 3 weeks was deemed too long. So this would really depend on the facts of the case. We also see the cases of Clegg and Anderson, Lee and York Coach and Marine. 6 months was too long to discover defect in the car. Cars, if you use it for 3 months, you should be able to know what the right defects are. Yeah. And also we've got other cases there. And in this case, you might want to engage with the cases, look at different cases. If you I know it's an open book exam, so we do understand if you can't remember all the cases. But I would recommend that at least have one case that you can contrast the main position with. So is there a case that said 9 months was not Fiat and Connolly, for instance, said the use of a car for for a period of 9 months was not too long. And that was because the buyer was in contact with the seller, letting them know this guy is stressing me out. And they kept telling them, yeah, you're fine. We sort that out. We sort that out. So by acting promptly, your advice to Mary in this case would be, Mary, time is of essence rather. Act promptly. So if she acts promptly, she'll be able to reject that washing machine and claim damages for a breach of contract. Now, note that if this were to be a consumer contract entered into after 2015, the relevant provisions would be under the CRA. Comparable terms for all of those things will be found in the CRA. But remember that the CRA, what we were banging on about before the break, the CRA is not subject to the rules of acceptance, that there is deemed acceptance. No, the remedies are set out in sections 19 to 24. So if there is a breach, the consumer buyer has an initial 30-day right to reject the goods. If the breach appears after 30 days, you can ask for repair or replacement. If that doesn't work, there's that final right to reject, and the consumer can also ask that the price be reduced. So this is to tell you if the question were to be on a consumer, that's the provision. If the leak is due to incorrect installation, the consumer is entitled to ask for it to be done again, and there are also stricter rules on the ability of trader, supplier to exempt liability. So you can't just show things like that down the throat of consumers. And finally, you might also want to talk about the consumer contract information cancellation and additional charges regulation. But that's, you can just mention that that's also relevant in a way, but you don't have to go into that, the provisions in detail. So we're not expecting, this is a, yes, absolutely. And that's what we're going to do now. Because the next question, test our understanding of the CRA. So I hope you got the structure of that. Quickly, I want us to run through the next question in the next 20 minutes before we. The cases are relevant, but the only thing is you have to be careful about applying the cases on rejection, on a deemed acceptance, because that doesn't apply to consumers. So going by the case that was cited by one of you earlier, I'm trying to see who cited the case before the break. That case was held in 1950s. The law has changed, so it would be relevant to business to business transactions. It wouldn't be relevant to business to consumer transactions. Yes. So rejection and acceptance, you have to distinguish because the provision of the CRA offers more protection to the consumer compared to the uh business, someone dealing as a business. So let's quickly look at, I want us to be able to cover this. So Christine, yeah, let's read that. I'll give us some time to read that. Yeah. So I see what you say about the part exchange. Now, for a contract to be a contract of sale, going by the definition in the of contract of sale in the Act, if it's partly price, it is still covered. It's still covered by the Sale of Goods Act. So I hope that clarifies it, Chung. I think we said that earlier, that it's a contract for mixed price, mixed part exchange. Yeah, we said that. Yeah. So because it involves an element of part exchange, will not prevent it from being seen as a contract of sales. And I said the authority on that is Snedden versus Durant. I hope that helps. Good. So now, quickly, what do you think about the facts of this case? How would you start based on what I've said in the last 1 hour? Good, good. Yes. Yeah, you discussed that, but very briefly, Chung. Okay. Contract type, good. Applicable law, rather. Yes, yes. The main issues, are we following? We're getting this, aren't we? So, talking about the first one, what type of contract is it? And okay, I'm seeing CRA 2015. So why have you decided that it's a business consumer contract? Why? Define consumer is defined by the 2015 Act. We're going to get to that very soon, but we've decided that it's a consumer contract because she's buying it as a birthday present for her daughter. That is outside. Very good. Oui, very good. She's buying it for a purpose wholly or mainly outside her trade, business, craft, or profession. And that's provided for in section what of the CRA? I want you to get in the habit of citing the sections. Section 2. So it's therefore good, good. So therefore, it's a business to consumer contract and it will fall under the CRA. It is a contract by a trader for a price. Remember, we defined contracts when in the last question. Here, we still need to do that. It's a contract for a sale. for a price, and that's section 5 of the CRA, right? Section 5 of the CRA. Accordingly, the terms will be implied into these will be sections 9, 10, 11, and 12. So you can make a point here and say that the wording of those terms are is so similar to those under the SGA. So the cases that have been decided under the SGA are also relevant because the CRA is just so recent. The cases are still being decided, they're being appealed. So it's early days, isn't it? So in addition to the implied terms, there also may be express terms of the contract that provide additional rights under sections 9 to 12. So we need to consider the status of any statements made by who? By Roberto. What are those statements, if you can find them in the question? What are the statements? As good as new. Very good. Yeah. Yeah, very good. So as good as new. And if you're paying attention to what we're doing here, we're pointing out the statements. So in the assessment, make sure you're doing the same. You're pointing out the statements that have been made right. So as good as new, only out of the box for a couple of days. It hasn't been turned on. It is an X demonstration with the same specification. So those are all the statements used to demonstrate that. And now you want to ask, what's the next question you want to ask about these statements? I want to be sure that you're following me. What are the questions you want to ask about the statements? Oh, you're saying the CRA is not fully discussed in our previous lecture. The reason we didn't discuss it is because the sections you're referring to, sections 9, 11, 10, 11, and 12, are in pari material with the sections of the SGA, but they've been added to the CRA just to ensure that all the relevant provisions are all together in a single document. So that's why we did, because if we're discussing them as well, we will be repeating ourselves. The only things that are different are in relation to remedies and acceptance. Swen. So does that clarify why we did not discuss those provisions? It's because they are the same. The ones that are the same were not discussed because we don't have the time to be repeating ourselves. Yeah. So going back, description. Yeah, but before description, you want to ask representation, mere path. Good for ye. Very good. So you want to ask, are those terms? Can you say these are mere paths? Can you say these are representations? Can you say these are terms of contract? And for that, you might want to go to the four elements I said, the timing, the importance, the writing, is a statement written down, or specialist knowledge. Now to answer your question, Lord Chi, the cases on the SGA are still relevant, except for when it comes to section 11.4, when it comes to the right to reject, when it comes to acceptance. Remember, the law has a higher level of protection. The law gives a higher level of protection to consumers. So the cases on that, like the one that was cited earlier, are not relevant to a consumer if it holds that you cannot reject. I'm trying to find a case now. Before that was before, not Ashton Piggeries, but there was a case that was cited earlier. 1950 case, yeah, that 1950 case. Where is it? I think it's hiding from me. Contract. Yeah, I don't know. Can't find it now, and we're running out of time. Yeah, you know the case. Yeah, maybe someone has found it. Let's see. Oppenheimer. Yes, that one. Yeah, Rickard's case. It was decided earlier. So you have to be cautious. Look at the provisions of the law, and if you see the decision that contrasts that clearly, you would know it doesn't apply. But it's very glaring when it comes to um, acceptance. We said a consumer cannot be deemed to have accepted the goods because he didn't return it on time. So those authorities do not apply. So does that, I know it seems confusing, but you just have to look at it closely and understand that the substantive provisions, mercantile, satisfactory quality description, they are similar. But now when it comes to rejection and remedies, a consumer has got a higher level of protection. Yeah, you have to look at the cases specifically. If it's saying the consumer has lesser rights, then no, you have to interpret it in conjunction with the uh, CRA. Yeah, we're going to see the cases that apply now. Let's quickly run through it before we're kicked out by time. So we're looking at you have to go through those things. Bannerman versus White on the importance of the statement, Rutledge and McKay in relation to the timing. If the contrast is reduced to writing, that would also be Rutledge v. McKay. And there's a final one, Dick Bentley Productions and Harold Smith, which is about expertise. So it's a person making the statement, an expert in that area. Yeah. Now, in this case, the statements do not appear to be written down, and the fact that it hasn't been switched on and is as good as new may be important because if you're buying a computer, you want to know, is it brand new? Am I getting a brand new thing? Yeah. So this statement, more likely than not, will be terms of the contract. So if there were not terms, then it can be established that they're false, then there might be a remedy in misrepresentation. But that's not the focus of what we're doing here today. We're looking at terms, conditions specifically. So there is no variety of ways to breach these terms. So it will not be an innominate term. The impact is the same. So straightforward. It's a term. And the fact that it has not been switched on is unlikely to go to the core of the contract. If it's not been switched on, doesn't change anything. If it's switched on, it's not being used, that's all that matters. So we can apply the case of Pusad and Spires on that. So it's not really clear if this has been breached. So that could be a warranty. Switching on a TV, yeah, I mean that's something that is just very minor that you wouldn't expect to go contrary to the contract. So in this case, we would argue that yeah, it may prove difficult to establish. How do you know the TV has been switched on or off? We don't know. So a statement that it is as good as new, that seems to be a statement about quality. It's as good as new. When we're saying something is new, etc., yeah, it's as good as it goes to the quality. Now let's start with section 11, which is the equivalent of section 13 of the SGA. So looking at section 11 of the CRA, it implies a condition into the contract that a sale by description, the goods will match the description. There does not, in this case, there does not appear to be any issue over whether she did receive the same TV. That was what she got. The issue would be to whether the statement that this TV is as good as new is one of the statements that forms part of the contract. Does it go to the description of this contract? Does it adequately describe the contract? Because it's a business to consumer contract, and one that was face to face. She saw what she was doing. The regulations, consumer contracts, information cancellation, and additional charges regulations will not. Yeah, so that may not be in that regulation. It's. I mean, since it's a business to its own premises, it is in scope of information, the regulations, the 2013 regulation. So they are obliged to provide the consumers with information set out in Schedule 1 of the regulations. And information becomes a term of the contract, going by Section 11.4. And it requires the main characteristics to be given. You need to let the consumer know what they're buying. So she may try to argue that the statement is good as new, is it goes to the identity of the contract, and she may be able to establish that the goods are not because of the defects she can find on them. And in that case, she can get a full refund, apply for a right under Section 19 of the SR CRA. She can apply for return it, get her money back. But if she did not succeed, she could argue that it was form part of the general requirement for sale by description. And the question I want to ask us is, do you think this is a sale by description? We know the act does not define it. So what is the case authorized? Oh, what is the case authorized that offering warranty does not lower? Yeah. So what we're saying is that because you have warranty does not mean you cannot claim your statutory rights. That warranty is something on top of the warranty, on top of your statutory rights. So it does not reduce the rights you have under the Act. I hope that clarifies it. So you want to ask yourself, was this a sale by description or not? We have 4 minutes to go, and I'm just thinking, are we able to conclude this? Should I leave the remaining section, the remaining part of our discussion for to answer questions, or do you want me to continue? I can continue from the point of was this a sale by description tomorrow? We can start by discussing because it is by description. You think so? Yeah. In that case, you might want to apply the case of Valley versus Weeb. You may also want to apply the cases of Grants and Australian knitting mills. There's also the case of Beale versus Taylor. But what matters is, does that description go to the identity of the item? To be part of the description, the words must be a substantial ingredient of the identity. If it's not, it cannot be a sale by description. So the question you're asking is, does good as new form a substantial ingredient of the identity of that item? Also an essential term so that it forms a condition of the contract, or does it merely go to quality, which is still a condition, isn't it? If it goes to quality, it's still a condition. You can go into the cases. Ashton Pigres herring meal was held to be uh, it didn't go to the identity. The court said it go to quality, but in Valley versus Whip, you can contrast that and say new last season was held to go to the identity. So the courts are divided on that. Like I said, the authorities we've applied in relation to um in relation to the other question also apply here. And I think you might want to now move on to talk about quality and fitness for purpose. So I think we should address those tomorrow as a starting point before moving on to talk about SGSA. SGSA is a quick one anyway. So we will be yeah, we'll have lots of time to tomorrow to cover what we need to cover. So now, yeah, thank you for thank you for letting me know. Thursday. Thursday, yes, on Thursday. On Thursday. Yeah. So when we meet on Thursday, thank you for correcting that. So I'm looking at the questions you've got. If you've got any questions, this is the time to ask before we draw the shutters on today's lecture. So it is, I'm looking at the comments. I think there was a comment I wanted to respond to. You say in the last question, yeah. Does that answer your question, Wong? Have I been able to offer some clarification on what you asked? It's in addition to. So you're still able to claim your statutory rights, even though you've got something in addition to that. Now let's see. Do we need to distinguish and state that the SGA applies? Absolutely, Dimri. That's the key thing you need to do because it will make or mar your outcome in that question. If it's a consumer contract, the CRA applies. If it's a if it's the other one, business to business, the SGA applies. So you need to point that out. So yes, we're seeing on Thursday, will retention of title clause and seller's remedies be examined? We will talk about that when it comes to passing of title, passing of property rather, and risk. So we're going to talk about that. Now, I think we should finish for today now. I don't want to hold you. Am I right? Is it 10:25 in Hong Kong? Oh, you guys have been amazing. You must be so tired. If you want to ask any questions, you can stay behind. If not, thank you all for engaging and see you on Thursday. Thank you all. Thank you very much. Good night. Yeah, good night. It's still afternoon in Manchester, but yeah. Good night to you. I- I'll stop the recording now. Yeah. So since no one's asking any questions, I'll end